All right, the court will call, hope I'm pronouncing it correctly, ROMINE versus GAVISH REALTY.
May I excuse you?
Thank you, sir.
Thank you very much.
May I proceed?
Yes, sir.
My name is David Townsend. I represent the defendants below and the appellants in this case, John and Rebecca ROMINE. As I'm sure you're well aware, this case involves a situation where at the trial there was perjurious testimony given by the real estate agent and her boss, the owner of GAVISH REALTY.
Well, let me ask this. Is this about a perjury case or about a contract case where the contract states certain obligations to pay and then the judge deciding after hearing the evidence that the contract should be enforced?
Well, I think the answer to that question lies in the record. It's clear that the judge relied upon the corroborating testimony of Sherry Kubla and Mr. GAVISH. If I did not believe that were the case from the record, I would not be here, because we have obviously, and it's the first thing I wanted to get to, is a tips and coachman consideration. It wasn't argued as such, but if there is some other way for the court to get to its result, other than...
Listen, I'm having a hard time understanding why the trial court could not have accepted the testimony of those two witnesses, even though it was impeached with prior inconsistent statement under oath. I mean, the explanation, as good or bad as you might think it was from those witnesses, was that I didn't understand the question before. The trial judge's job is to assess the credibility of witnesses and make those credibility determinations. We can't do that on a cold record here, and that's classic case of the trial court's responsibility to determine credibility of witnesses. Just because there's a prior inconsistent statement under oath doesn't mean, under any case law I'm familiar with, that you can come up here and argue that that testimony was perjured and therefore it's a reversal. I'm just not following your argument really at all.
Well, Your Honor, obviously, if this court is not troubled by what it sees in the record, then
well, the problem is this. We weren't there. Witnesses testified, Mr. Epley, your client, Ms. Kudla, and the judge made specific findings in the record about who he believed, and then he made a decision that the contract should be enforced. And I assume that no criminal charges were filed. Is that right?
Well, I don't know. Well, I don't know whether they were. I suggested to my client, and I know he sought counsel about it, whether that happened or not.
It's not in the record that criminal charges were filed. So what you have, in essence, is simply conflict in the testimony, and the judge believed one group of witnesses and what he determined to be an independent witness, and then entered a ruling and a judgment. Is that accurate?
Well, there's certainly a conflict. I agree with that, but the conflict is such that you have diametrically opposed testimony in the case of Mr. GAVISH, where he says, and I understand. Let me address your concern, Your Honor. When we talk about Mr. Epley's testimony, I don't think it has a bearing here. All Mr. Epley did is testify that when Mr. GAVISH came in, he told him that he had a problem with it. The issue is whether he told my client.
Didn't he show up at the closing and say, I have a problem?
He showed up and told Mr. GAVISH that. I mean, he told Mr. Epley that. Mr. Epley's testimony was he did not relate that to my clients. So Mr. Epley's testimony really doesn't have a bearing on the issue of whether or not the court relied upon perjurious testimony.
Didn't the court say that there was no one to support the testimony of your client and that the contract then should be enforced. And there were no amendments to the contract in writing, and the only thing he had was a he said, and he said the contract prevails.
Well, first of all,
Is that what the court did?
I don't believe so, Your Honor.
Well, on the transcript of the record, page 140, the court said, and the problem is there's no one else to support him, and therefore I obviously don't think that they can make a strong case for estoppel. And then he goes on to explain his ruling.
Your Honor, there were incidents there is evidence in the record supporting my client. First of all, the clause that he relies upon is not an ambiguous clause. I mean, it's a clause that says if you, Mr. Realtor, come to me with some proposal other than what we agreed to in this contract, then it has to meet my approval. Now that's...
Well, the proposal that has to meet your client's approval is the terms for the sale of the property, right?
Well,
the property is offered for sale on the following terms or on other terms acceptable to seller.
That's correct.
Your client obviously accepted the terms of the sale because he closed.
And
right?
under the circumstances, Mrs. Kudla testified in her deposition that each time a contract was brought in that was different from what was agreed to in the contract with the broker, that they modified the terms and they acquiesced in the commission, and that happened on 2 occasions. In the final occasion, you see that they actually went to a closing based upon the very figures that my client expected, based upon...
In essence, you want to use oral representations to modify a written contract. Is that what you're arguing?
No, sir. No, sir. I think...
Well, doesn't the contract state a specific percentage of the sale price as commission to the realtor?
But it also says that if you change the terms of what I deem to be acceptable, in other words, if you come to me with a contract with different terms, then I have to approve it.
So there were oral changes that you want us... The problem I have, candidly, is one, the contract is not ambiguous at all. Would you agree? The written contract?
I agree. It is
the standard real estate contract?
Absolutely, I agree.
There's no amendment to it. There's no appendix to it concerning the reduction of a commission. Would you agree to that? Would you agree to that? Well, first, answer my question, then you can vote. Was there a written modification of the commission to be paid to the realtor?
Not in the form of modifying an amendment to the contract. That is correct.
So is that a yes or a no? There was a written modification of these?
There was not a written modification to the contract.
And the court looked at the witnesses, heard them, looked at the conflict in the testimony from the deposition, and said, I'm ruling, and here's who I believe, the contract stands as written, pay the commission. Is that accurate?
That's partially correct. That wasn't everything that he said.
All right.
And my concern stems from the fact that the record shows that he relied upon the corroborating, impeached testimony of 2 witnesses to throw out my client's defense of equitable reliance.
Well, it wasn't impeached unless the trial judge, as the finder of fact, decided that the appellee lied, right?
This is like a catch-22. I mean, obviously,
no, it's not a catch-22. This court, I noticed in your brief that you made the suggestion that this court should review this file de novo, this case de novo. I don't know where you got that from, but I can assure you of the fact that on this type of issue, this court has no power to reweigh the evidence and reassess the credibility of testimony that was accepted by the trial judge when there's substantial competent evidence in the record to support the trial judge's finding. And if you have a witness that gives inconsistent testimony in a prior deposition and explains that and contradicts that at trial, and the trial judge accepts that, there's nothing, we are powerless to correct that.
Your Honor, as I stated in my brief, I don't believe, and I don't believe opposing counsel believes, that there is a case in Florida dealing with the abuse of discretion issue where there has been perjury committed.
Well, perjury is a conclusion. You know, it's a term of art. It means that somebody gave intentionally, false. I don't know what the legal definition of it is, but if the trial judge accepted the testimony, then it wasn't perjury, as a matter of fact.
Well,
right?
Then perhaps I'm here under the mistaken belief that an appellate court really has, and I guess that's what you're saying, has no purview to review.
Well, it's a pretty fundamental tenet of appellate jurisprudence that we can't reweigh the evidence.
Well, but you can determine whether there's been an abuse of discretion.
We can.
And
the witness testified at trial, and the testimony was inconsistent with testimony that the witness gave in the deposition. Am I right so far?
Absolutely. The court has discretion.
All right. And the witness gave an explanation for why the testimony at trial was different than the testimony in the deposition.
Well, but I don't believe there was an explanation. And when I asked the question, were you telling the truth then, or are you telling the truth now? The court, granted an objection and didn't allow me to ask that question. That we never really got an answer as to why he said yes or said no in the deposition and said yes at trial.
Well, you explored the fact that he had made a prior inconsistent statement.
I did.
The trial judge apparently believed his trial testimony, right?
Well, it did, Your Honor, but I guess I'm just troubled by the fundamental problem of having two witnesses depart from their sworn testimony in a deposition, and they come to trial and give something different, and a judge buys it.
In your motion for new trial, did you list a witness that the judge or the court was unaware of or was not called, or something that diametrically proved that the statement was correct at the deposition and incorrect at trial?
Well, there are no other witnesses.
Well, that's my point. We have all that we have. All of the people affected by it testified, and it's not going to get any better for us because we weren't there. And if the judge heard them, saw them, and it's obvious that he had a transcript, and he said, okay, here's who I believe, how can we, sitting here, override what that judge heard, saw, and through intuition and experience, determine what was true and what was not true?
Well, Your Honor, I'm here because I believe that this court had the inherent power to look at the deposition and look at the trial testimony and determine that there was an irreconcilable difference.
So you're inviting this court every time that we review a case where there's inconsistent deposition testimony that we should upset the jury verdict or the trial judge's finding. Is that what you're suggesting?
No, sir, not every time.
Have you got any precedent that stands for the proposition that we have the authority to do that? You say our inherent authority.
And that's the problem. There is no case dealing with the issue of abuse of discretion that mentions
what you're asking us to do is reweigh the evidence, and there's a million cases out there that say that we can't do that kind of thing.
Well, I know that it's a problem that occurs. I've practiced law for 35 years, and I've never seen such a dramatic inconsistency as I see here. It's very troubling to me. And I felt...
You don't do much appellate law then, do you?
Pardon?
You don't do much appellate law then, do you?
I'm sorry, I couldn't understand what you said.
You don't do much appellate law then, do you, when considering diametrically opposed testimony from either depositions from experts and then trial testimony, or from an opinion that's reconsidered but not letting anyone else know that you reconsidered? Your
Honor, opinion is one thing.
My point is it happens all the time.
I know it does with opinions, but opinions...
No, with witnesses and testimony, especially in cases of sexual abuse, where a young lady might say he did it and then come to court and said, never happened, didn't do it, I was lying, even though there may be physical evidence to support her testimony.
In this case, we have Mr. Gavish saying, no, I did not tell the ROMINEs prior to closing that I had a problem with the commission. He says no in his deposition at the trial. He says, well, yes, I did tell him. And he has, there's nothing in the record to explain that away. That is his that's perjury. He says one thing in a deposition, one thing at trial. And that's what's troubling. And I see where the court's going. I hope you understand why I'm here.
We do understand.
I feel there's been an abuse of discretion, and if the court's powerless to do anything about it, then I've done the best I can do.
Well, thank you, sir.
Thank you, sir.
All right. You wish to make any argument?
I don't believe so.
Okay.